Monday, September 17th. Call the meeting to order. Sandy, call the roll. Sandy.
Ms. Nightingale?
Here.
Mr. Sims?
Here.
Mr. Little? Mr. McMillan?
Here.
Ms. Jacobs?
Present.
Mr. Brisker?
Here.
Mr. Bordelon?
Here.
Yes, we also have Anna Dow, Larry Langston, and myself present. You have a forum.
Thank you. Number one, we have public comment on the following agenda items. Did you want to go, Molly? Anybody want to make a
I'm
comment?
sorry, did y'all say?
Yes, we're going to have public comment. Did anybody want to make any comments on the agenda items?
Yeah, I sure do.
Okay.
Nathan brought me.
No, go ahead.
I didn't really plan on this, but I just I knew it was talked about at the last meeting some, and I just picked this paper up, and to be honest with you, I had the right even time to read the whole thing.
Which paper?
But this about the absolute auction.
Okay.
I hate to be reading, but I mean, I know y'all have already read it and talked about it. But as I understand, this first thing says, no auction should be advertised as absolute, nor any advertising containing the words absolute auction, or the word absolute, or words with singular meaning, nor shall any licensee offer to sell any real estate, real property, real or personal property at absolute auction unless there are no liens or encumbrances on the real or personal property except property taxes, easements, restrictions of records in favor of persons, so forth and so on. And there again, I haven't read all this, but if this is what I think it is, it's totally, absolutely ridiculous.
What do you think it is?
Well, it means that if you're saying, and I apologize for not getting this earlier and reading it, but as I understand, you're saying that no one can sell anything at an absolute auction or advertise at absolute auction if it has liens or mortgages on it. Now, what would be the purpose? 90% of the stuff I sell has liens and mortgages on it. And anybody with wooden head knows that you've got to clear the lien or mortgages before you can transfer a title. It becomes our responsibility. But if I can't advertise a piece of equipment or a piece of real estate or anything else at absolute auction just because it has a lien and mortgage, you're absolutely crippling the sale of something terrible. I mean, you know, I've been in this business 55 years, and I guarantee you the vast majority of what I sell at auction and advertise at absolute auction has liens or mortgages.
I'd like to answer that as an attorney. I think this is being made in order to protect the consumer or buyer. Say you have mortgages of $30,000 liens of $30,000 on a piece of property. You advertise it as absolute, but there's only a $15,000 bid. How do you know that the mortgagees are going to relinquish that $30,000 mortgage rather than take title to it? You don't.
Well, if you have any credibility whatsoever in being an auction business, you understand that you can't transfer title without clearing the title.
Well, then you can't do it.
And I've been doing it 55 years, and I'm telling you that you can't. I mean, many times. I have a deal coming up in November, and I'm selling probably $10 million worth of equipment for one contract. All of it has mortgages on it, and it's absolute auction. It's going to sell regardless of the price. Now, we'll get enough, we feel like, to pay it off. If we don't, I did the same identical thing for this same contractor 3 years ago. I sold 10 320CL excavators, and our understanding was when we started that we would probably have to ante up $100,000 to $150,000 to $200,000 to pay them off. And we knew that before we went into sale, and I made a deal with the man that if you come short, I'm going to pay them off, and then you can sell some more equipment later on in life or later on in the year or sometime or another in order to pay me back the extra money that I've got to put up to pay them off. Well, if I put on my brochure, and I don't know how much you know about the auction business, but I've been in it for a while and I still learn every day. If I put on my brochure, sold subject to the owner's confirmation or creditor's confirmation, nobody would have been there. I had dealers from all over the world. In this particular case I'm talking about, these 320s brought more money than I expected because I sold them every one at absolute auction. I I had enough money to pay them off, pay my commission and still give the man a little bit of money. But going into the deal, I anticipated having to put up a couple $100,000. And so I don't know who we're trying to protect. I mean, we're trying to kill the industry is what we're trying to do.
Can you warn to this committee that all auctioneers are in the same position as you are with regard to honesty and fair dealings with the public?
I don't want this, no, I don't want, I've been in this business 55 years, and I want on my reputation, if I sell, I mean, there's a man right there that's in a car that sells cars at the auction. How many of them cars are floor planned through the, I mean, at the car auction? How many of them are floor planned?
80% of them are.
Right, they're floor planned at the finance company. I mean, you know, to me, this is the most ridiculous thing I've ever heard of in this industry, I'll be honest with you. I mean, that,
Well, it's not ridiculous if you just don't advertise it as an absolute auction.
and you don't get buyers there, that's what brings buyers to auctions.
Well,
One
I
at a time,
disagree.
one at a time.
I disagree.
Well, I just want to post my opinion, okay?
Your time's up, but did you have anything else real quick that you wanted to?
Well, I had
On
to
a
say,
different
and
item.
I appreciate y'all giving me an opportunity to mention this, and thank you.
Thank you.
If it's permissible and you need more time, I'll yield.
Next.
Well, if he had anything further to say and it's permissible by rules, I'll yield my time, but otherwise, no.
You don't have anything?
No. I expressed my sentiments about absolute auction at the last meeting.
I meant on anything.
No.
All right. Approval of minutes. I have a motion to approve the minutes. I have a first, do I have a second? Second. All in favor? Opposed? That's approved. Old business, approval of tested auctioneer applicants. Do we want to take these one at a time?
Number 6 is, the only one that has anything pending.
Just one.
Make a motion to approve 1 through 5.
And I'll list out their names in the motion.
I'll second that.
Okay, we have a first and a second. And everything's all right.
Yes.
Anybody have a question or comment? All in favor? Opposed? Ayes have it. Yeah, no. I'm passing this over. I'm going to
Because
recuse myself because
Tessa
I work
is
for him.
employed by him. Ashton Thomas is from the New Orleans Auction Gallery. He actually is currently an apprentice under Tessa. However, he just recently completed auctioneering school at the Fruit School and did come and take his test. He did submit an application to us, however, he did not get it notarized. So we're asking the board to approve his application pending his notarized
So
signature.
Motion made, that Ashton Thomas's application for license be approved, pending notary signature. All those, is there any discussion? All those in favor say aye.
Aye.
Motion carried.
Thank you. Number 2, approval of reciprocal auctioneer applicants. We have 3.
We have 3, however, the number 3, Mr. Gerald Yoder, has requested that his application be withdrawn at this time. I'll give you just a brief explanation as to why. Mr. Yoder is a retired auctioneer and has been asked to come out of retirement for an auction for Caterpillar. So he submitted his application to us, and then Caterpillar rescheduled the auction to 2013. So he is asking that his application be withdrawn for now, and he's going to reapply in time for January.
Because he doesn't want to have to pay the auctioneer's fee.
Exactly.
Okay, so we're going to do
So we
Stephen
have
and Kendall.
Stephen and Kendall, and both of their applications are complete and everything's
Taken together. Do I have a motion?
Second.
I have a motion and a second. Discussion. All in favor? Opposed? Ayes have it. All right, number 3, approval of auction business applicants.
Again, these are all, you can take them all together if you'd like, because they're all completed applications.
I'll make that motion, set 1 through 5.
I second.
I have a first and a second. Any questions, discussion? All in favor? Opposed? Ayes have it. Number 4, approval of apprentice auctioneer applicants. We have 2.
Let's take these separately, if you don't mind. The first one that we have is Richard Moore, and he'll be supervised by Autumn Garland is his brother. But his application is completely complete.
Do I have a motion? A second? All in favor? Opposed? Ayes have it. Number 2.
We have James Payne. James currently is an apprentice licensed with this board. He was just under a different supervisor. He is now requesting that his supervisor change, and he realizes he would be getting an entire year, so he's not trying to put a piece of one with another piece. It's just that the 2 supervisors we're talking about were business partners, and apparently they've decided to no longer be business partners, and James is staying with James Sims. So
Not James Sims.
James Smith, sorry.
It's the what?
He's staying with James Smith, so he's requesting his apprentice application be approved with the supervisor of James Smith.
And I call from this, I got a call.
Any motions? Make a motion.
Second.
Second.
Got a motion, second. You want to say something?
James on dedication. I talked to David a couple of times. And Mr. Smith has just dissolved the partnership. David's gone his way. I guess Smith's going to continue on with that business anyhow. And he asked me to relate it over with, this boy. He's a good individual, and if you don't mind, transfer his license. With his supervisor.
Anybody else? All in favor? Opposed? Ayes have it. Number 5, approval of reinstated auctioneer applicant Alan Person.
Yes, we have Mr. Percy, he's present in the room. Alan was previously licensed with this board from May of 2002 until 2009. It is because of the length of time that he was licensed with us previously, is not required for him to take any examination. His file is complete.
Move to reinstate.
For the second. The first and the second. All in favor? Opposed? Ayes have it. Okay, number 6. Mississippi Reciprocal Agreement Update. This is minutes. I spoke with the chairman, it's going to be our report. I spoke with the chairman of the Mississippi Auctioneers Board. I also,
I did, sorry.
oh, that's okay. Their application and hours, I went over with them. They meet every other month, the same as we do. They say they haven't turned anyone down ever who has filled out the form and done all the paper, completed the appropriate paperwork. If someone they have a 2-year renewal instead of an annual like we do. Theirs is 2 years. If theirs is in March, if someone wants to get a license in January, they tell them, really you should wait till March if possible because you have to pay the entire thing all over. And from what I just want to make sure I'm clear on this, that's what we do as well. If you apply in November and you get your license, you still have to reapply in January. The only difference that I can see with them is that they're 2 years and we're 1. Was there anything else I missed on that? He was very nice, by the way. He said, please, address any specific concerns. I might have been too vague with this, but there wasn't any other differences.
I have a question. How much are they asking for the application? Is it like $1,500?
No.
Because that's what I was told.
No, that's not correct at all.
Well, then apparently
That's why-
somebody up there gave me some bad information.
I believe so, because when, I don't have it right
That's
here, but
unfortunate. I have a copy of your application here. If you are an auctioneer by reciprocity, you would pay an application fee of $100, an out-of-state vendor fee of $250, a license fee of $200 for a total of $550.
When someone gave me some bad information.
I think
And
so.
Home Finders does business here. We're licensed in Mississippi. And I'm a licensed broker over there.
And we do the same for them, right?
Now, they do also, Darlene, I'm sorry, just to continue continue on. Just like us, they do also require a business license. So you would also be looking at a firm license through reciprocity, but also at $550.
Right, we already have that.
Okay, so, those would be the two. So, I mean, you're looking at over $1,000, but it's for 2 years for each license.
Right, so that equals our annual, basically.
Not exactly, because if you are a resident of Louisiana and you're looking to go to Mississippi, Mississippi is gonna cost you more money. But with the.
But I meant for Mississippi to come
But for
to us,
Mississippi
right?
to come to Louisiana, they pay Louisiana more money than what our Louisiana auctioneers pay Louisiana. Does that make sense? So let me say it this way, if you're not following along. Louisiana residents renew with this board for $150. It says on our renewal agreement that the renewal fee is $150 unless if you reside in Mississippi, the renewal fee is $225. Because they charge you guys $550 every 2 years. So if you put the $225 plus the $225, then you're up to. Sorry, I'm saying the wrong now, but it comes out to what they charge you guys.
Mississippi doesn't have a one-time fee for $200 per application.
Yeah, they have an application fee.
It's included in the $550 that I quoted.
Sonny always told me something different.
Now, they give Louisiana residents different information.
Well, I spoke to him and he confirmed all of that, but let's, let me call back the next meeting and just.
I mean, I was told this 2 years ago.
Well.
I don't know what you're doing now. When I was going to get my Mississippi license 2 years ago, I was cutting, and it all told me exactly 1,500.
That's exactly what I was told. Even though my company's licensed over that.
That's not what they told me.
There was another fee at one time, and I didn't look into this, but there was another fee at one time that you had to pay a separate agency in Mississippi for a business fee of some
Registration.
kind. That was, and I haven't checked into whether that's still available. That wouldn't go to the auction board, that was going to someone else. So it did
Yeah,
make,
they
it
don't
did
have
raise.
anything noted on their application
Okay.
about that.
But I will check into that for the next meeting, but, as of this conversation with them, we seem to be on the same page with everything. The only, like I said, the only thing was is the 2 year. Anybody else?
I just think when we asked you to talk to them too, that was, people were complaining that they weren't being treated very prompt and stuff.
He assured me that that was not the case, and to please call him back if I
That's
had
good.
any
At least they know that we
specifics.
were concerned
Right.
about it.
He
yeah.
said that they have not turned down one person. He was very nice on the phone. He said they have not turned down one person.
Who is he?
It's Marshall Riddick.
Reddick. I spoke with Mr. Reddick. It couldn't have been,
That's good, at least you brought it to their attention.
Right, he said they haven't turned down not one person from Louisiana who filled out the paper, the application correctly and had a bond. He said they've never turned down one person for any reason, except for, not having a bond or. But I will call him back and find out about the other fit. So I'll let you know at the next meeting. Any other questions? Okay. Let's move on to new business. Approval of financials.
Mr. Lamar's not here, so I'll just let you know, obviously, again, our fiscal year just began July 1st, so there really hasn't been any income other than, our applicants for this meeting, a couple of stragglers here and there. So it's not really it's a difficult report to look at this early because we're spending money, but we haven't brought anything.
Yeah, have we collected on fines though?
Yes, ma'am, yes, ma'am, and that falls under the auctioneer fee also. You gotta come at the top.
Move financial.
A second?
I'll say.
Any other questions? All in favor?
Aye.
All right.
Opposed? Ayes have it. Number 2. Attorney report.
All right, first of all, the status of judgment from July hearings, and this is something the board's gonna have to consider. First of all, Mr. Brown, as far as I know, is taking care of everything. Lindsay Hunter, who was the hearing officer, had contacted me earlier. She was trying to get confirmation that the complainant had been satisfied. She has not been able to do so. She will not be here today, so she advised me that as soon as she got confirmation, she would let me know. With regard, however, to Jerry Rosado, it's my understanding Mr. Rosado has not paid his fine.
He has not. I know that he received his findings of fact via certified mail and signed for it, but I've not received any communication from him.
So the board would have to make a decision, since he has not complied with the judgment of this board to pay a fine. They would have to make a decision as to whether to take his license, schedule a new hearing, or leave as is, I guess, would be the third option. If we have to schedule a new hearing, it would be scheduled for our next hearing date, November.
Have you all determined whether or not he had any extenuating circumstances as to why he could not pay the fine?
I have not talked to him.
I did talk to him. I mean, he can't afford it.
Well, that makes a big difference to me. Can we work out a payment plan?
If the board wants to do that, we certainly can see if we can work something out.
Rather than taking the man's license away, I would be for working out a payment plan. I don't know, is he a busy auctioneer? I mean, I don't think so. How much was the fine, Madam Chair?
It was $1,500.
So if we could work out a payment plan,
He
so
would, I
much a
think
month.
he would really like a payment.
And so what do y'all recommend on a payment plan? I mean, I don't want to take his license away. I would rather work on a payment plan and give him a chance. Times are hard for everybody right now.
Well, if you want to give us a time period in which to try to get this payment made, if you want to give 6 months or a year, we can work out a payment plan.
I'm thinking if it's a $1,500 fine, what about $100 a month? If the man's on Social Security, I don't know how old he is, I mean, I don't know what a Social Security check would be, but that's still a significant fine if you're not active in the business of bringing in money, and apparently he isn't. And yet, I mean, it's a deterrent for bad behavior. So I think if we could work out something, Tessa, can you check with him to see if $100 a month is acceptable?
You need an answer.
$125 a month paid out a year.
But he may not be able to afford that. $100 is a lot of money. If you only have an income of maybe
I'll ask him if he
$100,000.
can do
You want to
$125.
go ahead and put a time limit on and give him time to pay, or do you want to wait?
And that would be up to the board, you
We're not
know.
gonna wait, we're not gonna wait for 6 more days, that's gonna be November.
Y'all just talk to him and let him see.
If he can do 125, he needs nothing else.
Or 100, whatever, like.
I'm for 100. I think 125, if he's not active, if he's, up in age, I think that's a lot of money.
We need a
That'll pay it
motion,
for the
we
end
do
of
have a
2000.
specific.
Well, I know, but,
And that will pay it for the end of next year.
Yeah, and I mean, I think he's satisfying the board's decision. I think $100 is a
Did you want to
lot.
make a motion?
I'll make a motion.
Okay.
You enter into negotiations with him, to pay a minimum of $20 a month, and all work be paid by December 31, 2013.
Do I have a second?
I second.
Discussion. If he doesn't want to enter into this agreement, then at the next meeting, we'll take up action.
Right.
You want me to schedule for a hearing? Do y'all want to hear it, or do you want just to?
He already had a hearing.
Yeah, and that's what I'm saying, is, you know, you don't
They
have
had a hearing,
I think you
and
just
wait,
take action on it.
Yeah.
to. Okay, we'll just basically put this on the agenda.
So I would ask in your motion, maybe negotiation with action, be added if there's, can work out with that negotiation.
But if not, we'll put it on.
Where does he live, by the way?
He's in Kenner.
He lives in Canada, so they didn't really have any storm damage. They had a power outage.
No, I think
I'm concerned about anybody that may have been flooded since I was in 2005 after Katrina, and I know what a financial hardship it was on me and all of my friends. I wouldn't want anyone else to have to go through that. $100 that meant a lot.
All right, so we have you want to amend it, or we're just clear on what we're going to do?
I think it's clear. So-
Okay, I have a first and a second. All in favor? Opposed? Ayes have it.
All right, before we get to the absolute auction, just to update everybody, Ms. Vito's has determined that she does not want a hearing at this time. She does not need a license, and she's asked us to postpone until November. And she'll decide, hopefully by that time, whether or not that we're going to have a hearing with that. The other hearing, which is Joe Wilson Auctioneers, I had a request from the complainant to postpone. He could not be present today. I spoke to Mr. Wilson. Mr. Wilson did not have a problem with postponing it, so it's going to be scheduled for November also. We have one other issue that needs to be addressed. We have an auctioneer who is apparently did not renew his license and continue to auction. After that point, his name is Wade Desertel. We have determined that he's been noticed. He has, as far as I know, not auctioned since we noticed him the fact that he could not auction. He had a cease and desist. He's actually had 2 cease and desists at this point. And I sent him a subpoena asking him to provide us a list of all the auctions he conducted prior to this July, and he has refused to respond to that. It was my understanding that he was going to have his application in before today, and we have not heard from him. He did, I think he got just a fax.
I got a fax copy of his bond.
Which started in July. And I don't know, the options we have is to set him for hearing and see if he will come. He technically, right now, is not a licensee, and as such, he could say no and not come if he wanted to do so. We can go to court and have an injunction issued against him, a court order.
Who's the auction?
Himself. Yeah.
Where's the auction?
John. I mean, he was, I think, I had the investigator go, he was auctioning rabbits and chickens and various items. So that basically, you know, it's a question what the board wants to do right now.
There is a hand in the audience, so now I'm sharing.
I was gonna wait till she finished,
Okay.
and I'll.
But anyway, so the options are obviously see who's going to auction again.
And he's not auctioning now, right?
To our knowledge,
Where's he from?
he's been auctioning in Acadia Parish. He is actually from, I think, Evangeline Parish.
Where's he been auctioning? Where?
He's been auctioning in Crowley. Yeah, that I know of. Now, he may auction elsewhere, but that's what I was asking him to provide information.
I was recognized by board members. But livestock, rabbits and chickens fall up under that particular act. You don't need a license to do that in Louisiana. So that's
Yeah,
a total.
I'll follow up livestock.
Yeah, rabbits and
I
chickens.
didn't check that
poultry.
out before we did anything further.
Poultry does, and rabbits do also.
I like the motion to set it here.
In a second. Questions, discussion? Okay, all in favor of the motion, say aye. Opposed? Ayes have it.
Okay, with regard to absent auction, I looked at auction statutes and regulations from other states with regard to how they handle it. This particular item I've given you is rather broad. It covers a lot of areas, some of which you may not want to do, none of which you may want to do, but I thought I'd give you as much information as possible. To make this simple, this basically says that you cannot advertise an auction as absolute, or advertising containing any of those words, and you should not do an absolute auction. And remember, our earlier definition of absolute auction is sells at any price. That's how we divide it today in our regulations. You know, A says there are no liens, encumbrances, etc., except property tax, etc. Unless, and that's what we get to. This is an option for the auctioneer to actually be able to go forward with it in their liens, and each and every holder of those liens or encumbrances or mortgages by execution of the auction listing contract or furnishing to the auctioneer written evidence of a binding commitment therefore shall have agreed to the unqualified acceptance of the highest bid. In other words, the person who has the mortgage would agree to allow it to go, sell at any price, or alternatively, that someone, including the seller, agree that they would take care of the obligation, and these in case that the particular item did not sell for what it was mortgaged for. Right. It could be the auctioneer, as Marvin was talking about. It could be the seller. That could be simply there would be an agreement in place to protect the mortgage holder. There has to be, B simply talks about the fact that there has to be a real intention that at the time of auction and transfer ownership, regardless of the amount of the bid, that intent exists without reliance on any agreement, you know, that there cannot be a reserve, there can't be an agreement to the contrary made by anyone. C says the auction listing contract contains a binding requirement that the auction be conducted without reserve and includes an acknowledgement that the seller or anyone acting on behalf of the seller should not bid in the process, because obviously that would create a conflict of interest as far as that's concerned. However, they say that you can do it under these circumstances. The seller can bid. A secured party or the lien holder is not the seller. Basically, can bid. In other words, the bank can come in and bid, just like we do at the sheriff's sale.
Just a sheriff's sale.
Just like a sheriff's sale. Basically, the individual party can come in if there's an individual involved and it's a corporate mortgage, for example, a business mortgage, they could come in and literally bid, especially if basically. Someone can, an individual party or heir of an estate, a succession, basically could bid as a specific entity, or the, okay. And the inclusion of, as long as you put this in here, that it's going to be sold at absolute auction and it's going to be specifically identified for sale at the same date and place. And if there are things at that auction that are going to be sold by reserve, then those items would be specifically mentioned in the advertising. You couldn't say it's going to be an absolute auction and then take some out at the actual auction and say that. You can still, it is allowed by section 3130 of our statute, you can still bid on his or her own behalf if it's been disclosed. And finally, no licensee shall knowingly receive a bid by or on behalf of the seller in absolute auction. And if you got, and the final one says, any advertisement or representation of a minimum or suggested starting bid, basically, would be forbidden at an absolute auction.
Yeah. First off, I may be kind of lost because I missed last meeting, but I guess one of the questions I want to ask is why I didn't bring this up. And two, when I was at auctioneering school, our auctioneer teacher basically told us all auctions are absolute, that you had to more or less claim reserve and reserve stuff.
Well, that actually is true.
So all auctions are deemed absolute. If it's an auction, unless you have a reserve on it, then that price has to be met, then you have the option of not selling. But, I mean, absolute auctions mean absolute auctions. So why aren't we trying to redefine a term that is very specific in nature? And if it's sold and it has liens on it, I think with Mr. Henderson and what he was saying, I agree with a lot of what he has to say. People come to absolute auctions because they feel like it's going to be sold that day at that time. You put the word reserve in it, you're going to have people backing away from it because they know they have to meet a minimum reserve.
We're not saying you have to put the word reserve in it. We were just trying to clarify what absolute auctions, a more specific definition, because ours was pretty vague and we were having questions with it.
That we get back to it. Why are we putting this on there, and why is it being questioned? What the heck?
I'm questioning it as a licensed real estate broker in this state and also an auctioneer. As a licensed real estate broker, before I would put up anything at auction, we go and we trace the title and make sure that we know exactly what the liens are. There are very few people in this state that hold both licenses as an auctioneer and as a real estate broker. And some people think it should be mandatory. Back a couple of years ago, they tried to get a bill passed to do that. I just think that if you advertise something as absolute, and it's not really absolute, you've got a bunch of liens on it, you have to get above those liens in order to be able to get clear title to it, then you're deceiving the public.
And it's not absolute.
No, it's not absolute.
Reserve, right.
Absolute is absolute.
So don't say without limit or reserve, because that's what absolute
And
means.
Darlene, you see why I said what I said last month about absolute auctions?
Exactly.
I know no one that does them.
Right.
Even the
There are
Marvin
very
does
few
a
people.
few.
Well, Gilmore does in my area. They do it, and I have seen them
But
advertise absolute, and then at the last minute take it down because they call around different people and say, how much are you going to bid? How much are you going to bid? And I had King Auction do the same thing to me on some property that was advertised as industrial real estate in Slidell. They see who the high bidders are, they want to know what they're going to get, and then they take it off. And people are just getting tired of it. It's deceiving the general public, and I do appreciate the position that this gentleman is in with machinery. I don't auction machinery. I auction real property, which is real estate, but I don't think the general public should be deceived, and I think that you're inviting lawsuits when you don't have something in writing. It's not up to the court to decide what this body means with regard to absolute. It's for us to say what we mean and to have it in writing so that all of our people can follow that.
Can I ask you a question? Elaine?
Sure, I wish you would. Can I come and stand, please?
I, with Hal, am a little confused on this issue. Are you saying that you want to advertise your auctions at absolute, but you will have a reserve? No. So you're saying, okay, so you were saying you want to advertise it at absolute, but you won't have any reserve. Then why do you issue with the
Let me
word?
explain this. Obviously, some of you, and I'm not trying to be smart, please understand that.
I'm
Been 55 years, and it supports a lot of families. It supports
I'm
my
sure it
family,
does.
Not just my family. We have probably 50 employees, and not just our employees. There's people makes a living around this auction business.
Lauren, we understand, and we're not
So I
trying to put you out
might
of
be wasting your
business.
time, but I'm just trying to explain to you how important this is. You mentioned stuff in here, and I don't know where you come up with all this law you talk, but get a permit from all these mortgage holders. Did you realize what a job that would be? We have an auction sale, sell $25, $30 million of equipment. James Industrial Contractors, not Roe Brothers in particular, I think all their stuff is paid for, but most contractors owe money on this equipment. Do I have to go back to CIT and
That's not what it says.
that's what it says.
Now,
That's
let
what
me-
it says.
let me
You have to have
clarify.
specific
Wait.
directions from the owner to allow you to sell it at public auction. That's what this says.
There's an alternate to that. If I may, can I
Why
address
is it even in there?
Wait,
I'm
no,
still
no,
asking the
explain
question, why is it
what
here to start with? I can tell you why it's here to start with, if you'll allow.
Let her explain
We-
the or.
Can I say that?
Can you let her explain the or, and then we'll move on, because you're moving on, so let her
Explain
explain the
what now?
or.
But basically what you're saying is, yes, that's one of the options you have. I tried to put as many options in as I could in this so that we could examine all of them. The other option here is that when you do your agreement with your seller, the seller agrees that you will be able to take the money to pay the mortgage, and the seller would be obligated to basically supplement that amount to make sure that you are paying the lien.
In other
But you're
words,
gonna have to do
you
it.
think that we are so stupid that we would sell something for X, Y, Z, and we, first place, we do title search. If it's real estate, we do it, we do it on equipment, unless we know for sure that this contractor or this dealer is solid and he has good title. If we don't, we do UCC mortgages. Now, if we don't UCC on it, and we understand that we've got to satisfy that bid. And we've got to
Right, that's all we're saying.
Yeah,
So what's the
but if we
problem?
go advertise it, this is gonna be sold subject to this, all of this, like the spouse says, you're not gonna have anybody there to sell.
Well, like I said,
I mean, people not gonna come. This is
You
not
don't
a
have-
local
no one
business,
is
this is
saying-
a worldwide business.
No one is saying that you have to advertise it that way.
no, we're
Well, in
saying
the first
this,
place, if it's not broke, why do you wanna fix it?
but that's
Because
the
it is
issue.
broke.
I don't
That
see
is
anything
broke.
broke.
All right, y'all, we're
Real
Exactly.
estate broke.
we're gonna do one at a time.
Okay.
Okay, thanks, Marvin.
Can-
You want to finish your comment?
Well, go ahead.
Okay, but how you want to have different questions?
Well, back to my question at hand, you have two terms. It's what we were taught in real estate school. You have an absolute auction, where everything there is gonna sell, no matter what the bid is.
Correct.
And you have a reserve auction. I think those two terms work. They've been working for years. They've been working in states across the United States. If you got a reserve on it, then you've got to come out and say, hey, we have a reserve on this item, when we meet the reserve, then we'll sell it. That kind of takes care of liens and real estate and stuff like that, in my opinion. An absolute auction term,
It means
you
it's
can
gonna
find-
transfer, it's
it's
gonna
gonna be
sell
sold,
regardless of
it's gonna be
price.
sold regardless of price, and we have to put some confidence in our auctioneers that they realize if it has a lien on it, and if it's a $30,000 lien, it sells for $25,000, somebody's gonna have to make up that $5,000 difference in an absolute auction, because that is a absolute auction. That's the definition of the term. I don't think we really need to change the terminology of what we've been using for years, and it works right.
That's what I'm saying.
Well, I don't know what the old terminology was. I thought we were just clarifying because we had, so can you address
It's
that?
what I understood.
Okay, let me say this.
Wait, let him speak and then you can have your turn, okay? I would appreciate if y'all be respectful to the
Madam Chair.
person who has the floor.
And I still have the floor, but I'm sure I wish we could get back to raising our hands and let us speak one at a time, and then I'll give the floor back to you. But if you keep those rules of order in, that way we don't have this cross-talking, because everything everybody says here is very important to hear.
Absolutely, and I would give everyone a turn, but I mean, everybody
Thank
yelling at
you,
once
Chairman.
isn't gonna solve anything. All right, Emma, so will you please address that issue?
And as I understood the issue from last meeting, was that the question was, if you have a lien or a mortgage on a property, if that is creating a reserve. In other words, you have two issues. One, are you creating reserve? And again, I see that there's auction, absolute auctions, and, you can put reserve auctions. I don't think you ever have to say reserve, you have to state it at some point if there's reserve. But otherwise, the state of Louisiana is going to sell on that day. The problem that I've seen in the past is what happens when you have an absolute auction, you call it an absolute auction. You've got a lien, you don't bring in enough. We have defined absolute auction, the use of the term in advertising, as you have to transfer that property that day, which means that if you didn't bring enough money in, how are you going to pay for the mortgage? How are you going to pay off the lien? If you don't have anything in writing and you don't have any protection, it has to come out of sometimes the auctioneer's pocket, or they get sued. And we've had complaints of movable property for that reason. And that's why, basically, as I understood the problem that I was trying to resolve.
Do I still have a floor? She's addressing my question.
Right, we still have the.
Okay. In that, I think we're maybe tailoring something for a few people that really is not that major of a problem if you look at the definition of the word absolute. And I've worked with other auctioneers where we've auctioned off different property, and in part of our explanation to that person, in the beginning, we tell them this is an absolute auction, and this is the definition of absolute. Well, toward as we got close to that auction, that guy said, well, I'd like to reserve this here. I need to get, sorry, sir. From the very beginning, we've told you this is an absolute auction. An absolute auction means everything will sell that day of the auction at that price. And it's the responsibility of these businessmen that have these big businesses, as well as Mike Peterson in our part of the world. He knows those things. That if there is a lien and it doesn't get to that part, that either the owner or he's making arrangements for somebody compensate that difference in there. I don't know why we're rewriting this. It seems to be two very basic terms, in my opinion, absolute and reserve. Now, if you have a reserve on it, reserve means you meet X price. If you don't meet that price, then either you don't sell it in the auctioneer. Sometimes collects fees or not. But with that, there's two terms. And we learned it pretty distinctly in our auctioneer school. Our teacher taught us absolute means absolute, reserve means you have a reserve.
how, before I know, I recognize I'm ready to talk, but let me just get this clear. How is it worded now as opposed to this? What exactly is going to change? What do you propose to be changed?
Right now, our regulation says an absolute auction, and something that's advertised as absolute auction, you must transfer. That's what it says. It's going to happen regardless of price, whatever. The issue I see, and I think this covers what you're talking about, it simply says, and this to me protects the auctioneer, is the fact that it requires it to be in your consignment contract. And maybe I should trust people to know, but I've never seen a consignment contract for an absolute auction. It says that it's going to be absolute, that you're responsible, the seller is responsible. That takes the burden off the auctioneer, because in some cases we've had situations where people have sold vehicles without a title in hand. They've had to pay off the mortgage holder. They did not have enough money to pay off the mortgage holder. And the purchaser was upset because they could not get a title to the vehicle that they purchased at an absolute auction. So this provides for a way to deal with that. It does, however, and I agree, the board is telling the auctioneer they have to put something in their consignment contract, which should be really good sense. But I don't know if people are doing that when they're doing an absolute auction, getting permission from the seller and also getting permission, getting agreement from the seller to make sure that lien is going to be guaranteed.
So what you're saying, let me just get this straight before we move on. What you're saying is you don't want to have to put that in because it's your option if you would like to pay that as the auctioneer.
It's my responsibility as a
Right,
businessman.
okay.
There's already laws on the book. If you sell something that's mortgaged, you got to pay it off. Or you
Do
just,
you have an issue with that as long as the auctioneer takes the responsibility?
That's up to the board. Anytime we get a complaint that, you know, I could not get the buyer said I could not get my item, I bought it at an auction, now they're telling me that there's a mortgage and they can't get the title, that would fall back on the auctioneer to be responsible for.
So do you understand what she's saying here?
I understand what she's saying, but I don't see why then there's another law necessary to take care of those kind of things.
You don't see what? Say that again?
Why would there have to be more laws and more regulations added into to cover things that's already there? You're trying to reinvent the wheel. There's also, every auctioneer has a responsibility to deliver the item, or there's other means, there's civil suits that he can go back to. Let him sue. Lawyers need to make money too. So, I mean, that's totally ridiculous. And as I said before, to go through all this paperwork and all this kind of stuff, I mean, it compounds and compounds. We're already overloaded with work. And, you know, I just think it's totally senseless. I understand why this came up. Joe Wilson sold at absolute auction, Tranquility Bay, in
Wait, stop.
Why?
Wait a minute now.
Why?
No, Jim, we're going to let
We're not having a hearing.
Marvin, stop. Okay, we're going to stick to this.
This
We're
is
not going to
all
go
that.
into specifics. No, we're not. We're going to stick to this and we're not going into specifics.
Then I'll move that this
I-
was tabled.
No, I would like to say
Hey,
something.
Al had the floor, yield the floor. Okay, you
Okay.
were next.
I would say, look, you all are assuming that every auctioneer will use due diligence and be responsible in tracing down liens and encumbrances on real estate or property. And the problem is they're not. In the last 3 years, I've had to serve as an expert witness on at least 4 cases, and I can give you the particulars on it in court, where this very thing came up, where people advertised an absolute auction and they never got the property because of the liens and encumbrances.
Well, that's where you
Wait.
I really think that it's not up to a court to adjudicate what we mean as licensed auctioneers. It's up to this board to adjudicate what we mean as licensed auctioneers. And the courts are going to look to this board to see what they mean as a licensed auctioneer in carrying out their mandates and in giving their decisions on cases.
All right, Jim, you want the floor? Go ahead, sorry.
This is not your answer to do what you want to do. Your problems are the police.
I tell you, that's what we do. We don't do
Let me get through. Our problems that Marvin here is talking about, 99.9% of it's on movable property. There's 2 avenues to check for liens. One is a UCC, the other is a division of a motor vehicle it's got wheels on it, it's got a title on it, Louisiana, if it's a mortgage on it, it's a Department of Motor Vehicles. Very easy to check. Check the Secretary of State and UCC. Now, if y'all want to do something on real estate, I don't have a problem with that, but I got a problem with this.
Well, that's what I do is real estate. I have a problem when
We need to, all I'm saying is separate the two. As I told y'all last month, when I went to auction school, which was 1974, a long time ago, we were encouraged not to use the word absolute because it causes problems. All my auctions I've ever done have just been strictly advertised as an auction. In my contracts, well, I do a lot of mistakes. In some cases, they have encumbered movable property. And I go to the bank with the estate attorney, we make a deal with the bank, that we pay the bank out of the proceeds of the sale before the family gets his money. And Marvin's saying the same thing. We're taking that responsibility to get it done. Now, I don't have a problem if we want to sit down and do something about absolute, separate the two, movable from immovable. Honest to God, I can't vote for this, not the way it would. And I respect Anna's position, don't get me wrong, but I also know where this came from. And I in good conscience, I mean, I showed this 4 auctioneers between last Thursday and today. And they just, 3 of them didn't have a comment, they were just a deal like this. The 4th one won't know around here to do it.
I don't know if you can separate it, because that's the problem.
Yes, you can separate, you separate 2 different rules and regulations, if that's what you want to do. But I'm like, I can't see fixing something that's not broken. I mean, I know we get complaints, I understand. That's what civil courts are. If we can't settle it, then it goes, I'm like, oh, you can go to civil court, you see. Because 9 times out of 10, it's not the auctioneer's fault. It's that way.
Mark, you had one more comment before I go to Freddie?
Yes, I haven't even on real estate. I understand you cannot transfer real estate unless you get satisfied the mortgage offer. I mean, it could be satisfying you by transferring that note to the new owner, or whatever means it might be. But if my auctions, if I advertise absolute, you can bet your boots it's going to sell. I'm going to sell it to somebody. I may guarantee the price. I may guarantee that you're going to get $1 million when you get through that day. And I may have $2 million worth of mortgages on it, but we've already know that we're going to have to make up the difference. I'm just trying to keep from crippling the sale and adding a bunch more hogwash paperwork to everything we try to do. I mean, anybody knows that you can't sell anything at an absolute auction unless you pay it off to the previous owner or make arrangements. And that's all this is all about. And you're creating a bunch of hogwash here over an incident that happened that I'm not going to, I can't say what the incident is, but I had very strong emotions about it. And it was strictly a volunteer thing.
Thank you. All right.
It was volunteer.
Can I ask you?
I just asked you to trash the whole 5 big thing.
Can I ask Dana a question?
No, I just want to say, I don't have a position on this. This is up to the board. This is an auction issue. I see a legal issue here, but auctioneers can make the determination. There's certain things that should be in every contract. An auctioneer should be right enough to cover that, in their contracts. They do this a lot. If they don't, he's right. Assuming the auctioneer ends up being responsible.
Survived 55 years.
Well, and it's, I just wanted to assure Mrs. Sims, I don't have a position. This is not necessarily my position. Well, you sort of did, but okay. But the question is, this is what I was asked to do by the board, and if you tell me that you don't think you like this part, or you like this part, and we can amend it and change it any way you want.
Is it possible to, or acceptable to maybe reword it to have this be applicable to real property only, and not to, rather to immovable property and not to movable property?
Sorry.
I mean, is that?
I mean, I can amend this pretty much.
Can that be done without tainting the wording of, of the proposition that you have before us?
Freddie, I promised him, Freddie, you right now, come up to the podium, please.
Yes, ma'am. Very brief. Thank you all. I raised my hand several
Yeah,
times.
you did, Freddie, and I was trying to
Yes,
get to you.
No problem. Let me just say this to the board in general. You know, it's not a separate entity that we have to deal with. I feel that real estate does an excellent job of covering, protecting not only the seller, but also the titles and things like that. They have more applications to go through than we do. But at the same time, the issue that we're dealing with, and all of us must be honest with ourselves, is an issue that needs to be addressed. There are particulars that need to be placed in contracts that clarifies a lot of the uncertainties that exist. Ms. Jacobs is right, Mr. Henderson is right in his position, but when you look at it, it has to be up under one umbrella because we're dealing with auctioneers, not real estate agents. And then the real estate people deal with theirs. Jacobs is an auctioneer that sells real estate by auction. That method of marketing is what the umbrella we're under. So what I'm suggesting is that what Ms. Dow presented is just a general definition to clarify some things that are very vague, and we all know that they're vague, but you can't cater to one and not to all. We have to address the issues that are pertinent to protecting the public and the public's interests, at the same time protecting the auctioneer and the auctioneer's interest, that everybody's on the same page when they come together. Ms. Dow was correct. Very few contracts have the specificity of absolute auction written in it, and terms and conditions are not there. So my question is, are we going to continue to circumvent, leaving the language out, and then leaving it up to someone to imply what is being said rather than what is actually being said?
Thanks, Freddie.
That's well stated, Fred.
Thank you. Okay. Morgan, you want one more quick thing on this subject?
Yes, I'll refer, well, I got it. I'll refer back to the real estate thing. And of course, I'm not a right licensed broker. Currently in Louisiana, you can sell real estate without being a licensed broker at auction. But nevertheless, I've sold some real estate at absolute auction a couple, 3 years ago. I sold 9 acres of them yet. And it was like mortgaged under $400,000 or something. I can't remember the number. I was aware of that. I advertised it positively will sell to the last and highest bidder at absolute auction. I understood that I had to satisfy a first mortgage or I couldn't transfer title to it. And had I advertised that to be absolute auction and not brought that kind of money, then I had to come up with the money or somebody had a very strong libel suit against me. So that's what courts have already said those things. But, you know, I didn't circumvent any laws and I don't have to do it. And it makes the real estate, as Hal says, if you don't want anybody to come, you say subject to owner's reservations. And that's usually, if I'm doing this, I put in there subject to owner's confirmation, if it's going to be subject to owner's confirmation. And you don't get anybody to come. I mean, I've seen it over and over and over again. And if you want to kill your auction business dead at 4 o'clock in the morning, just put subject to the owner's confirmation or with reserve. And nobody shows up.
Thank you. Okay, anybody else on the board? Last comments?
I just want to make a motion.
You do? Any other comments before?
I make a motion that we keep absolute auction definition as we've had it in the past for right now.
Second. All in favor? Opposed?
Aye.
Motion passed.
That's all I have.
Okay, number 3, application and renewal forms. You want to explain to everyone, if someone has any questions about the military, the legislature, Act 276?
No, you were right on that.
Okay. So we want to add that.
That's just the board to decide.
That's on the application questions.
It's a question of, do you guys want to be aware of when someone has filed bankruptcy? Do you want it added to the application? It's not currently there.
There's no way, don't spell words now.
discussion just because there's been a couple of licensees recently who have filed bankruptcy, and because of that, have used escrow accounts and such to pay their personal debts potentially. And it's potentially.
Or is it happened, or is it something?
There's an allegation of that.
It's general specific.
So.
I mean, I don't have a problem with it over, I'm just wondering why all of a sudden, you know, standing answer, I was getting one of the states with it, you know. I mean, I could care less what they said, you know, about Dixie. But, you know.
I don't know that other states are doing it. The issue came, and just let me say this, you know, every so often we'll get, somebody will call in and say, so-and-so filed bankruptcy, you know. We can check on that. We can just sort of rely on complaints to come in. Sometimes the issue does come up about a bankruptcy. We've had one within the last year that I know of, and we've had one prior to this, both resulting in hearings because of issues that arose during the bankruptcy itself. It's simply a matter of, that's something the board thinks they should know about ahead of time or require the licensee to inform us of it.
We have a motion? Okay. All right, I'll speak up, so now we're going to go on to
Now we're going to the
Act 276. If you want to explain it.
And you want to do it, I mean, I can, but
Well,
if it's legal.
I mean, you got a letter from.
I got a letter.
Yeah, oh, you got a letter from.
Yes, it was addressed to the chair. It just says that, well, let me just read this really quickly in this one. Governor Jindal has signed Act 276 of the 2012 legislative session, which sets forth new procedures for the licensing of military-trained applicants and military spouses. These changes will address two major problems in the state of Louisiana: veteran unemployment and military spousal unemployment. Each professional or occupational licensing board must adopt rules that outline the implementation of the new law. Please keep us updated on your progress in this matter, and if you have any questions, contact the Department of Veterans Affairs.
Do I have a motion to add this?
I'll make a motion to add it, but I would like discussion.
A second? A motion, a second.
Yeah, basically, what does this say, I guess, is the definition.
What it's saying is that we have to basically give, you know, for example, someone came in and said, I learned to be an auctioneer while I was in the Army. We have to accept that to some extent as experience and potentially as education for our requirements. In other words, we can't say, wait, you haven't gone to one of our licensed schools. We have to sort of give a little extra step for it. You know, line with this is a little complicated because it's not really addressing our issues with regard to licensing. It's addressing other boards and other license requirements, to my knowledge, but we have to comply with it. So the first step I think we would have to do is simply find out whether anybody actually falls within the statute that's applying through us. And this basically says, did you have military training or military experience as an auctioneer? Or basically, are you a military spouse who is certified, registered, or licensed in another state as an auctioneer? Potentially a military spouse who is already licensed auctioneer in another state as a reciprocal. It would be the same that we do right now. They would not have to wait for the next board meeting. They could automatically go in and start auctioning it.
Right, and I'm for helping all the veterans that we can, getting jobs and everything, but we do have specific regulations now. Are we talking about waiving the test also, or are they still just waiving the time that they would have to have served at auctioneer school and still have to take the test? What does it say there?
I think that
I may have the answer to that. It says that they would have to have completed a military program of training, been awarded a military occupational specialty, and performed in that specialty at a level that is substantially equivalent to or exceeds the requirements for licensure with this board in which the applicant is seeking. It still says they have to go through the process that the board has set forth, so they're not.
Right, they still have to go through the process.
They
So
would
they have to be tested and they have to be bonded.
My understanding is that yes, they would have to be.
bonded.
That's the only thing you waive it is the school.
I have no
School
problem.
and experience, that's the
You know,
experience.
they meet the criteria, I have no problem with it.
The other thing, just to put forth really quickly, is that it does specifically say that if they have received either that training as an auctioneer, or if they're a military spouse who is coming licensed from another state or another jurisdiction, that they are issued a temporary license. So there is no holding time where they're unable to work as an auctioneer. They be issued a temporary license at the time their application could come before the board, where they have to show that they meet all of your requirements.
I can specifically address this statute because I was involved a little bit with it. If you're familiar with your MOS, your military occupational
Service.
category, they really were doing this mainly because there's some categories such as surveyors, engineers, and as such. And they have an MOS that's exactly the same as the Louisiana's engineering and surveying stuff. So it was really designed for that kind of category. There is no MOS that I'm aware of for
Auctioneer.
auctioneers. Now the issue is the wife, but since you have reciprocity issues, I don't think you really have a problem. But you need to develop some type of a rule for it.
Right, and that's what we're gonna.
Are there any licensed auctioneers, is that auctioneers in the service, though?
Not that I know of.
No, this is after they come.
Everything goes to certain registration.
This is out there.
Okay.
Now, I just theoretically, yeah, you're right, there's no specific occupation, but suppose you worked in the part of military, whatever.
Liquidation.
Selling, yeah, that's a different thing. But you can have, like, if you're auctioning, if you're in procurement, et cetera, and you are doing surplus auctions, I don't even know if they exist, but I think our first step was to identify those individuals who may fall under the statute. That's the only purpose for the questions to be asked.
I mean, gotta do the law, gotta do it. I mean, I don't have a problem with it. I think we'll have everybody in depth.
Would you agree with that?
I mean, they take it from this property. My God, that 4 kills Saturday. You know, I mean, I can.
Okay, so I have a first and a second. All in favor? Opposed? Ayes have it. You will make that change for us? Ann?
Yes, we'll add that, and then Anna and I will work together too, and just kind of narrowing down the rule for you guys to implement. This was kind of the first step, was get it on the application so that we are immediately compliant, where we're aware of who meets that criteria, and then we'll figure out how to.
And you'll send respond to that letter saying that we
Yes.
added that on, since that has to be updated. Thank you. Number 5, policies and procedures for handling complaints. Review the scores and
What this basically deals with is how this board goes about doing investigations and handling complaints. I, for one, have gotten a lot of complaints about the way this board operates, and I can't disagree with about that type of thing. Most of the auctioneers I've talked to in the state say they want the board informed before there's ever an investigation started. I can't disagree with that. They said this board operated for years upon years, the board decided whether to investigate something or not to investigate something, it's done very well. I understand some of the things that are being investigated now, how to sense it. True, we probably should know about it. Or at least the judges and that's and folks and everything too. But basically what my people in North Louisiana want, they want the board to have a written set of policies and procedures how investigation and complaints are handled. And they want it written by the board, not the board attorneys.
does everyone understand how this is handled? Anybody have a question about how it's being handled?
No, I've never seen a procedure, if you need advice before, I've never seen a procedure on how we handle complaints, maybe we need to be educated on that. Since I've been on this board, I haven't seen exactly if there is a complaint, how it's handled, how it's taken up, who our investigator, I don't have a clue on that kind of stuff. I need to, and I don't know who the rest of us, yeah,
I've never
so,
seen anything that's policy procedure in writing. I've never seen.
and we as board people should, or board members should know exactly what's going on that behalf, and I'm kind of, with Jim also, I don't necessarily have to have all the nuts and bolts, but I think we need to be informed that, so we don't get blindsided with something, especially if it's in our area, and there's an investigation going on. As a board member, I think we have some obligation to know what's happening with this board. And I don't know.
Whatever time.
So, thank you.
All right, I'll be glad to address.
Yes.
And
I will be handling that.
okay, prior chairman asked, what I used to do was I would address specific issues, not facts, but issues, and ask the board, which is what I did last time.
Recommendations.
About a specific issue with regard to a pending complaint. And then the board would say go forward or not go forward with regard to that. A prior chairman asked me just to tell the chairman what is going on. So I can, the chairman, not her, prior chairman, asked me to notify the chairman when there was a complaint or an investigation, or sometimes the chairman would tell me. And then I would consult with the chairman as to go forward or not go forward. I never do it on my own. The problem that we have with going, basically with too much information is there was a specific statute in the Administrative Procedure Act which says specifically that you cannot know the facts of a case in detail prior
To hearing it. That's
which
right.
you could, that would mean you cannot talk to other people about it. You cannot get information directly. You cannot investigate it yourself. And far in the past, we had board members who were doing their own investigations, which caused other issues in addition to this. But that is not anyone on this board. So that what I've been doing is basically consulting the chairman, except in the situation you recall, you appointed Mr. Bordelon as the contact person for me for New Orleans Auctions. Since Tessa worked for New Orleans Auctions. So I've been consulting with him, and he's made all decisions with regard to going forward on that particular issue. I don't have a problem with policies and procedures. They probably should be done in line with these statutes involved. Well, I talked to Lindsay Hunter, who is your hearing officer and advisor on hearings. She advised me that different boards do it different ways, and she was going to get some of this together for me. She says the one that comes to mind immediately, she has one board that you will, every time there is a hearing or an investigation or a complaint, one board member is appointed by the board to consult with the investigators and the attorneys. And then that board member has to recuse himself or herself from the hearing, because you cannot both direct the investigation
And be a part
and
of it.
then be a member of the board that actually hears the investigation, hears the complaint. So if you hear about it, you have to recuse yourself, is what she says. She is going to give me that information. I was going to put it together and see if that's what you want to do. But I need to get some feedback from you as to what you think should be done.
And I think basically what everybody's really wanting to do is it's not really wrong. If there is a complaint, who's it with? And make sure, I think it's all one. As far as the procedure goes, investigation procedure, that's what I have no way informed. I don't get involved in that, know anything about it, and what it comes down to. The procedure of the hearing, I think the board should be getting packets, this is my opinion, of evidence or whatever, instead of us having to pass around some key papers. We go out of a hearing, and that hearing starts, everybody's in the packet with all the evidence, mark, and everything you interviews it, whatever you need to do. I want to, and I think that'll solve a lot of the problems.
Well, as far as the hearing procedure,
far as the hearing procedure.
I'll certainly take that up with Lindsay because she makes that decision. With regard to the other, again, my problem with giving names and allegations out loud in the meeting is that people hear it and they judge
That's
the
what
conclusions.
executive session for, being litigation. That's totally.
Yeah, that's what the board desires.
Well, maybe you could use a facsimile on a name.
Howard.
I'm sorry.
Well, and I agree with what he's saying, but also, I don't know the protocol. If I had someone that, auctioneer or myself, that saw somebody out there that I needed to get you to file a complaint, I'd like to have a list of what is the protocol, how do we do it, other than me just saying, hey, I need you to check this guy out in this area. I'd like to have a true protocol of procedures of how to handle a complaint.
We do.
We have that.
Well, I hadn't seen
I've
it.
never seen
No,
it.
no, no, no. No, how to
Sherry
handle
had that.
the protocol, not how to handle it. That's what it's, that has changed on how to handle a complaint, because I've been on the board since, and it's changed a few times.
That's the kind of information I would
Right,
like
but how
given
to
to
make
me
a
that I could
complaint
read up
is
on.
definitely set up. You call the office, there's a form to be filled out and so forth. As a board member, that's different.
As a board member, I don't know how a regular auctioneer that's not a board member would do it, nor how I would do it as a board member. That's something that goes back to part of the education of what we're doing up here. I need to be enlightened.
Yeah. I mean, we can definitely tell you that. You call the
Well,
office, and there's a, I'm sorry,
Excuse me.
there's a form to be filled out.
Okay, thank you. I do it for.
I think the big problem is most of the auctioneers in this state, especially in my area, feel that the board's authority has been turned over to this whoever's form is, Attorney General's office. And I got shut down when I first brought this up a couple of weeks back. But, you know, I can't disagree with these guys. I mean, these guys pay money to be a licensed auctioneer. And I'm sitting down here representing. Well, if something's going on in my area, especially on high-profile auctioneers, and I don't know it, then I get blindsided with it, and I gotta sit there, look like a little old talker roll in first grade, don't know what's going on. It's embarrassing. If I had what I'm asking for, which wouldn't be a legal problem, I don't think. No different than this attorney going to grand jury, getting a true bill, and it's public record the day it goes to court. There's no difference. Yes, there is a complaint, yes, there is an investigation going on, and that's it. That's all I would tell them. But I can at least get the answer. And I ain't got to call and aggravate Sandy, or aggravate you, or aggravate Alan to find out. I'm sorry.
I think what Governor Jindal wants is transparency with the work boards. What I would like, if possible, is that before we have a meeting, if we're going to have a hearing, I would like a set of facts. And you don't have to use the name of the person. You can use Mr. X or Madam Z with regard, and also give us an idea as to what the infringement is before we meet to adjudicate. If that's possible, without using any names. Because I think if I had that in advance, I'd be better prepared. I think Freddie had his hand up.
He does. I didn't know if you wanted to respond.
Yeah, that's what I've been trying to do, is basically give you just the basic situation without giving specific names.
I have not got it before hearing. I mean, I get it the day of the hearing. I'd like to get it before.
That's what I discussed the last meeting about the hearing that's coming up in November, was the fact that this is the set of facts, which brought no discussion on that.
Yeah, if we have something in writing, and that way I could be better prepared for it.
You want it prior to the hearing or prior to the
Yes,
hearing?
I would like it prior to the hearing.
I'd like it to be bailed out at least 10 days before the hearing.
What do you want specifically? Are you?
Yeah, but before
Okay.
hearing, we have a complaint, and we could have the responses provided prior to that. I'll check to make sure that's.
And I think
Is it
as a board,
possible if
we'd
you
be better
put
prepared.
the evidence exhibits in?
Well, no.
Sometimes yes, sometimes no. Sometimes it's
I know
third-party
some things
complaint.
that are legal.
Well, no, there's
Application,
some
but-
are third-party complaints. I advise a third-party complainant, for example, to provide us with the documentation ahead of time. And sometimes I have to subpoena it, but certainly, you know, I don't see a problem with the complaint itself, because we do not generate, unless the board asks me to, we do not generate a complaint in-house. We do that in third-party complaints.
Would you have a problem, you or Larry, you the ones that y'all represent, both attorneys that represent the board, the 3 members of this board, write the policy and procedure? We got an attorney on the board, people legal with the statute.
And I've asked for some suggestions from the Attorney General's office with regard to that, to give you some guidance on what is legal and what is not. And I don't have a problem if you want to do that. I just want to make you aware that any complainant or any auctioneer can come in and say, you have too much information, I don't want you hearing it, and I don't want the board recused from any board hearing because of that, because you have too much, information before.
I see where you're going for, and I don't want that.
Okay. And that's what
not what we're asking for.
And I'm not having a problem with giving you more information if you tell me your procedure and how you want it done.
How do you want it handled where, if it's in your area, you want to be called about it?
Can I make a suggestion? Let me, Greg Borland, Hal, with Darlene looking over our shoulders, since she's an attorney, let us put something right.
Al shaking his head no. Al shaking his head no.
Busting sunshine rule if we do that this morning.
What?
You can't have that many board members meeting.
Get it for
You can email or back and forth.
So you want to have a committee?
Yeah, our committee's always got at least 3 people.
But I would not want, I would be happy to serve on any committee, but I would not want to usurp Attorney Dow, because I think she's done a lot for the board. And I want to make sure that we're within the guidelines of what we need to do.
Can I make a suggestion, which is what I was planning to do, is at the next meeting, because this came up so late, I couldn't get it from the Attorney General's office. They have promised me, they're going to provide me with a number of different procedures and policies that the other boards use. I'll even provide you the one we use for interior design. And you can look at those, maybe choices which you think is best, and then I or the Attorney General's office or Darlene or one of us can put it together so that you can implement it and do it rulemaking. That would be, basically sometime first part of 2013. I put that out.
I'm happy to do whatever y'all want me to do.
Freddie, you want to make a real quick comment?
Yes, ma'am. Thank you, Madam Chairman. I in the past have asked for a lot of information prior to just to be informed, but then at the same time, I know Mr. Sims is wanting to know what's going on in this area, which may prejudice the board or even interfere with the investigation if it's someone, that he's given privileged information to. Not say he is, not say he will, but the point still lies that some things are better kept as close as possible until it's disclosed, because you don't want to prejudice the board in their opinion of the person before they get a chance to hear him. So, there are a lot of violations that could very well happen as a result of this, and I think the board needs to be very cautious in proceeding in that direction, as Ms. Dow has stated. It is something that we may not want to do because it may cause maybe some problems that leaks out and stuff like that, because it always comes from the inside. We know that when it gets out there. It doesn't come from the outside, because nobody knows what goes on even in this room but the ones who are here. So it may be something advantageous to the board to consider.
Okay.
I do have a question. On the complaints, they say somebody complains to our attorney. Well, is it a decision that's made by the attorney to follow up on that complaint, or is it a board decision before that's pursued? What's the usual protocol on that?
The standing protocol has been that,
Chair.
well, because Anna brings it to the board, before the hearing, and very
First,
vague in general.
I first made the chairman aware that there was a complaint.
Without names.
And the circumstances behind it. And she will tell me, because I don't pretend to be an auctioneer. Sometimes some of these complaints are very much involved with practice. So I have to ask somebody who knows. She's the chairman, she's the one I report to on my contract. So I asked her, is this something I should go forward with or not go forward with? And she advised me and gives me direction with regard to what I'm doing. And I do basically what she does I do make recommendations sometimes. It depends on the complaint and the circumstances.
But I don't know the part, who's complaining, I don't know who the complaint, they're complaining about. Well, she'll call me, which is a general. So this person is auctioning without a license. Do you want me to send an investigator? Oh, yes.
Yeah,
you know,
And
it's been very, you know, like that. So I don't know any specifics.
Right, and then if you want me to, then whenever the Vito's complaint coming up next, I brought to the board as far as what the circumstances were. The Wilson complaint, I brought to the board what the circumstances were, the board told me to go forward with the last meeting. You just advised me, went ahead and mentioned Mr. Desentell's name because it's a license, it's someone practicing without a license, which is a little different circumstance. And I brought that up. So
I didn't really realize that was happening.
Mhm.
That's a lot of responsibility for one person as a chairman to take on. Maybe that, she has two other board members or whatever, she bumps that off of before a single source decision is made. That might be something we want to look at also, too. It may not be a valid complaint. And, you know, it's a lot of pressure to put on her. Maybe you implement something where we have a couple different checks.
And the question is, you can't have too much information. Again, that's the problem.
Well, it could all be generic.
It could all be generic, and in that case, that's not a problem. It depends on how, it's just that, again, we went to start doing this practice a chairman or two ago, and that's just what I've been following under the direction.
The biggest complaints that have come in, I've been accused on telephone, right? So that was in it. And the other ones, I've had like 3 or 4, and they were very general, just questions. Should I do more investigative work?
And maybe you check with those other boards, see if they bend it all to the chairman or one person.
No, the one you told me about specifically was they appoint either, in one board, they appoint a committee which is not made of board members. And then they advise as to whether or not this is a violation of practice or whatever. Another board says, okay, we're going to appoint, you know, this particular individual to monitor the investigation and the legal proceedings, but that individual, if they monitor it that closely, cannot, they have to recuse themselves. So it's a question of how, and I don't have a problem with, you know, this is up to the board. I don't have a problem how you want to do it. It's just that you also have to realize that if you take on responsibility for monitoring an investigation, you have to recuse yourself, and you have to be very careful that you don't get in the middle of the investigation, because you're not protected by state law from your immunity if you go beyond your positions.
I think between what Mr. Sims said and myself, we're giving you a lot to get back with us
Sure.
next week.
That's not a problem.
Thank you very much, Madam Chair.
And Mr. Simpson, you put this on here, are you happy with that? Anna comes back next time with more specific, and then we'll go on.
I'm going to bring you back specific ways other boards do it.
And you'll look at if it's in the area, if that's a possibility. Or we can maybe put the chairman in person in the area. Can have a,
And you need to tell me how much, because if you
Right.
have too much means you cannot
whoever's
be
area.
involved.
Just general specifics. I mean, they didn't got to be like,
Right.
we got any names.
General, general specific, that's a con.
No,
Okay.
I understand exactly what
I
it
know.
is. Okay.
So we're good on that. All right. Number 6. Transfer capital outlay fund to separate bank due to FDIC limits, but I think you have.
Right, I can make this very brief, actually, because I'm aware of the fact that the FDIC insurance limit is $250,000. I was looking at our bank accounts. I was concerned about that. I thought maybe we needed to move some funds. I have since learned some insider information. I have an email from the representative at our current bank, and she says that as a public fund entity, you are already collateralized for balances exceeding $250,000. As your balance grows past $250,000, the National Collateral Group will pledge securities at the Fed on your behalf. So in other words, it was something I was concerned about, just heading into renewal season soon, that we would exceed that limit. She assures me that we don't need to worry about that because they will pledge on our behalf and our insurance levels will. So it's a non-necessary item.
Any questions?
I just found that out on Friday.
Okay, next meeting date, November 5th.
It's a week early because of Veterans Day.
First Monday, brother.
It's the first Monday in November. Here.
We'll be here first Monday. All right. Have a motion. First and second, all in favor?
take a 15-minute recess.
No, we're on 15 minutes, 5 minutes.
Well, we've been 1 o'clock, so technically it's going to be 11 minutes. Right, so let's